Okay, you can let them in.
Okay.
Hello?
You're in the meeting, Miss Richards.
Okay, thank you.
Okay, Ms. Clifton, you can go ahead and call the case. Wait, let me take a brief pause. Okay.
This case number 18005-370-CH, Sabrina Crawford v. Wayne County Investment Group et al.
Okay. Good morning, counsel. Appearances for the record.
Good morning, Your Honor. This is Carrie Floyd appearing on behalf of plaintiff Sabrina Crawford.
And good morning, Your Honor. This is Tracy Richards appearing on behalf of the defendants, counter plaintiffs.
Okay.
Good morning, Your Honor. June Sung, also representing the plaintiff.
Okay. I know today was the day and time set for the trial, but let me just first note that the only motion that we have preceded for this morning was defendant counter plaintiff's second motion in limine and motion for sanctions for withholding documents. That's the only thing that we have preceded today. So what we'll do is we'll handle that motion, then we'll go off the record and discuss some procedural issues and in terms of how we're going to proceed going forward. Okay.
Okay, thank you, Your Honor.
Ms. Richards,
Your Honor, okay, thank you. Your Honor, having reviewed their response, my concern was, why did they wait so late to provide me with the information? The response that was provided is that, well, one of my interrogatory responses said, please provide me with all information except pleadings that pertain to the parties. However, Your Honor, I know I submitted a request to produce which asks for any and all documents that you plan to use during trial. Notwithstanding, with respect to the bankruptcy petition, we'll start with Jasmine McMorris. Her bankruptcy petition does not mention the property address at all. Period. There's no dispute about that. And in fact, that's very similar in this case. The parties don't dispute the facts. We just dispute how it relates. What is the law on this? So the reason that the plaintiff wants to use Jasmine McMorris' bankruptcy petition is just to show, well, she committed a bad act during that time. Therefore, she committed a bad act during this time. So first of all, they haven't proven a bad act that she committed. But second, and more importantly, obviously that's inadmissible character evidence under Michigan Rules of Evidence 404B1. That will be evidence of other crimes, wrongs, or acts, and they're not admissible to prove the character of a person in order to show action in conformity therewith. Period. So as to Jasmine McMorris, I think it's clear that her bankruptcy petition, which of course does not mention a property address at all, or any of the parties, is not admissible. Because now, with respect to, go ahead.
Let's do one at a time, Ms. Floyd.
Okay.
So I also just would like to, I know that we didn't precipitate our motion to show cause or the motion to compel we just filed it this morning. So it's a little bit hard for me to fully address Ms. Richards' issues because if the court will recall, we had filed a motion to compel because defendants didn't turn over this information to us, and it was something that was within their purview. They had these documents. We asked for them in discovery and they didn't provide them. So the court issued an order compelling them to respond to interrogatories. We didn't receive their responses until late last week. After I reviewed them over the weekend, it was very plain that they were responsive, and frankly nonsensical. And so when I, asked the defendants to supplement, they've indicated they won't. We also filed a motion to compel this morning regarding those documents and that information. So we're working a little bit without the full information because the defendants won't turn it over despite this court's order.
Okay, but let's deal with Ms. McMorris in terms of even the relevancy, So what, she filed bankruptcy if she didn't reference the this property? What's the relevancy? You don't get, everything that they have in their possession at time. It has to be relevant.
So while the bankruptcy doesn't address this property, it does address Ms. McMorris's companies. To date, we've received nothing from Ms. McMorris regarding her companies. We've alleged that she uses these companies as her alter ego. The complaint at issue here is actually evidence of a fraudulent transfer between her company to the companies that are the defendants in this complaint. Without consideration, it mirrors the transfers, the fraudulent transfers at issue regarding this subject property, and sort
Okay,
of
but
demonstrates
now, I don't know, and maybe Miss Richards was the Miss McMorris's bankruptcy, was that individual or is that as a corporation?
Let me take a quick look at the exhibit.
And I can answer that, Your Honor. So it's her corporation. It was the corporation. We actually sued them in the
Okay.
original. When we found out they were bankrupt, we dismissed that corporation. The issue is
Oh.
that she transferred property to the corporations that are still subject to this lawsuit.
Okay, Your Honor, I definitely would like to address that. First of all, it sounds like she's bootstrapping. So if we even look at, in order to be relevant, we have the cause of action. I actually have a copy of her complaint, Your Honor. So I think it's clear that if this relates to any...
Excuse me, you're referring to her bankruptcy complaint? Or what are you
No,
talking
no, I'm
about?
sorry. No, I mean the complaint in this case.
Okay.
In other words, I'm trying to show that this is irrelevant. So I actually looked at her complaint to see, okay, what possible causes of action? Of course, I could not find any. So again, she admits that the bankruptcy petition relates to Jasmine McMorris' company, and then she also said that this is a company that filed bankruptcy. So again, that party is actually out of the case. Even more reason that this is irrelevant. And then further, she's trying to show that, okay, she's doing fraudulent transfers that mirror the fraudulent transfer that was done in this case. But, Your Honor, in this case, first of all, that's not even one of the counts. There's no count for fraudulent transfer, period. There's not one. I have the complaint in front of me. That doesn't exist. You can confirm that. And then also, again, she's talking about, quote unquote, bad acts. And again, that's inadmissible. So if anything, her argument just shows why the defendants, the company defendants, should be dismissed as well. And maybe the court will give us a chance to address that in a motion, because if that's how she's trying to tie everyone into this case, then obviously that's inadmissible.
So, Your Honor, we have alleged that they use these companies as alter egos. We've also alleged that they're the agents, that they have an agency relationship. So the cause of actions are explicitly related to these companies. The other issue is that MRE 404B allows evidence like this to come in if it demonstrates a modus operandi or a system or an act of engaging in a particular behavior.
How does
That's
it?
what
It
we're
does
alleging.
the bankruptcy. And like I said, that, to me, this is just creating, a red herring, and it's going to take us off on a tangent, because, it's too much. We're getting too far afield from what the issue is. So, after consideration, the court is not going to allow Miss McMorris's bankruptcy in, because in terms of prior bad acts, it's not admissible. So we're not allowing her bankruptcy in, and then the court also finds it is just a red herring. It has no relevancy at all. So as to Miss McMorris, the court is denying the is not allowing the bankruptcy, and so the motion limiting is granted as to Miss McMorris. Now let's go on to Miss what's her name? Miss Spratt.
Lori Spratt, yes.
Yeah.
And Your Honor, just with respect to Jasmine McMorris, since she filed a motion this morning and I have not had a chance to review it, as to any allegations regarding Jasmine McMorris, I can just ignore those, because
Right. We're not dealing with,
okay.
I'm not dealing with
Okay.
that. The only thing I'm dealing with this morning is the motion in limine that's before the court.
Okay. With respect to Lori Spratt, so her bankruptcy petition does mention a property. In that bankruptcy petition, she mentions that something about this is one of her properties. So, that I can see is more relevant. However, that issue doesn't appear to be relevant to the actions that will be heard by the jury. The jury actions relate to the illegal eviction. And again, I have the complaint. I can read that. So if anything, I definitely want this court to not allow it with respect to the illegal eviction because it has nothing to do with that. Now, going to the issue at hand about the motions we filed to determine motion, interest, and property and what have you, this bankruptcy petition at the time, so first of all, as I stated even before.
Hold on, Ms. Richards. We're not
Okay.
dealing with those issues today. All I'm dealing with is a motion in limine. So
No, that's what I was just about to say. At the time when I first found out about the bankruptcy petitions, I spoke to my client. She said, I did not provide that information to the attorney. That's the response we gave. So when I answered the interrogatories with my client, she has very limited information because she did not provide it to the attorney. This is her answer. This is what she's sticking to. If you look at the plaintiff's response, and they say on number 2 of their response, and let's see, what page would that be? That would be page 2. Let's see, I'm sorry, no, that would be page 2 of their response.
wait a second, give me a second.
Actually, you know what? Let's see. Exhibit 2. Actually, no, I'm sorry. Number 4. If we look at number 4, it's on page 2. Number 4.
Wait, hold on for me.
Okay.
Where did that go? I think this is it. You said page 2,
Yes, page 2 of the plaintiff's response.
right? Number 4.
And number 4, where it mentions that defendant Spratt strongly opposed the dismissal, showing up to the dismissal hearing with $9,000 in an attempt to avoid dismissal. Okay, and then they say, see Exhibit 2, dismissal. But when you look at Exhibit 2, there's no reference to this $9,000 that they speak of. So, in the court, if the court wants to take a minute to look at that.
1 second.
And I can clarify for the court, we have the audio from that hearing, and that's exactly after reviewing the audio. So the dismissal is for the failure to confirm the Chapter 13. The audio of the hearing demonstrates she didn't want this dismissed. She showed up with $9,000 trying to confirm the Chapter 13 plan. But I can address further the arguments if the court would, regarding relevancy, if the court would like me to.
No, let's.
Okay.
No.
Okay, so I wasn't finished.
That's what I'm saying. I was going to say that in terms of, so you're saying that the reference to the 9,000 was in the.
And also, that was in response to the fact that in their motion, they claimed that she dismissed it because of the information wasn't accurate. And that's just frankly not true and contrary to the statements that were made to the federal court. And that's the only reason we attached that dismissal is, to the extent that that information was false, it's false. That's not what happened.
Your Honor, this is the day of the motion. If that was true, the audio, they could have easily had it transcribed. The plaintiff doesn't have to pay anything for these things. So this could have been transcribed and provided to the parties. I know I asked repeatedly if you have this information provided. Several times, Carrie sent me an email. You can get it. You have just as much information as I can to get it. And I said, I can't find out. I don't know what you're talking about. So, again, that's not here. And today's the day for the motion. But even going further, Your Honor, with respect to the petition and the mentioning of this property, this court may recall, we the defendant's counterplaintiffs, have a count for rescission. And that rescission count is based on the fact that at the time the land contract was entered into, Net Management did not own the property. Net Management didn't own it. Lori Spratt didn't own it. Leonard Spratt didn't own it. So even though this petition may say that Lori Spratt owned the property, we're saying obviously she was wrong. Now, was it perjurous? No, of course not, because obviously at the time, this is what the information provided to the attorney. This is what they believe, but obviously it was inaccurate. Further, at the lower court, during the lower court proceedings, the 36th District Court, as well as the appeal of the 36th District Court action, none of the parties mentioned that Net Management didn't own the property. No one mentioned Tiana Copeland, who actually owned the property. They were all under mistaken belief. obviously, if 36 had this information, I seriously doubt that it would have ruled the way it did. That's why this is a perfect case for rescission, Your Honor.
Okay,
So again, I'm saying that I can
but
see
now,
if, oh, go ahead.
I allowed you, but remember, we're not dealing with the rescission. I understand what you're saying.
Right.
My only concern today is relative to the motion limine and then the bankruptcy, Ms. Richards. So that, that's the only thing. And you know what, at this juncture, what I'm going to do is I'm going to conditionally allow her bankruptcy to be referenced. But of course, the foundation is going to have to be laid during the trial to show its relevancy. I understand that it was mentioned. So the mention of it is enough to allow it to go forward. Of course, in terms of just referencing any prior bad acts like was asserted in Miss McMorris's situation, if it's just for that, of course, Ms. Floyd, the court isn't going to allow it. However, if it's determined that there is some other basis, then the court will consider it. But just to bring it in to show a prior bad act, it's not going to be permitted. So in that regard, I'm sorry.
Can this be outside the presence of the jury?
Well, in terms of when we get ready to go to trial, everybody's going to be prepared, and if there's something that needs to be raised before the jury, of course.
And thank you, Your Honor.
I'm just wondering if I could put this in the order.
Yes, which all you need to do is place. Yeah, you can place it. It'll be this issue. Well, it's not really taken under advisement. The court said that the bankruptcy can be used for the purpose of any other purpose other than showing that a prior bad act.
And that's not what we're intending to use it for. It's a direct statement of her ownership interest. That's the reason it's relevant. That's what the suit is about. So that's our intention to use it for that matter.
So like I said, yes.
Your Honor, she just mentioned it. So this has nothing to do with the jury trial issue. Remember, all the issues concerning the property are going to be decided by you. So the jury has no reason to hear this if it pertains to the property, because their actions pertain to illegal eviction. That's what the jury is going to be concerned with. All claims related to this alleged illegal eviction, which has nothing to do with who owns the property. Oh, go ahead.
But like I said, this juncture will allow it. And, we'll see how things shape up after we do the bench trial. And then,
and Your Honor, we have not addressed that procedurally, whether the bench trial will happen before or after the jury trial. You've wanted to do motions for summary disposition before reaching that issue.
Okay. But like I said, but still, as I indicated, we'll make a determination at a later point in time. So the motion is, let's say it's conditionally denied as to Ms. Spratt, and based upon what the court articulated on the record, we'll review it at a later time. Okay, so Ms. Richard, your order will indicate that motion limine is granted as to Jasmine McMorris. However, it's conditionally denied as to Lori Spratt, and clearly as to any prior bad acts, but any other use of it will be determined at a later point in time.
Okay, so I have conditionally denied as to Lori Spratt, and the court will review it at a later time.
Yes.
Okay. Okay, so can we talk about the pretrial order?
Okay, wait, this is, we're doing, this is the motion here. So are we finished with the motion? Are we? Okay, so that concludes the motion hearing. Let me stop the recording.
Oh, okay.
And then get off of YouTube Live as well. Give me 1 second.